Good morning, everybody. It's Bernard Nomberg. It is it's Thursday. So we've pivoted from Tuesday to Thursday. It's 10 o'clock. It's another episode of Nomberg Law Live. And I'm so pleased to have my guest today, Birmingham attorney Bo Johnson. Good morning, Bo. How are you doing, bud?
Bernard, I'm doing well. Thanks.
I sure appreciate you being on today. I'm looking forward to our topic. For those of you who don't know of Bo or haven't met him yet, you need to. Bo has a very important niche in the law that he handles, and that's dealing with children and families who have special needs, and more specifically, dealing with their education. And it is a real finite area of law, and I applaud what Bo does because so few attorneys do this type of work, but so many families absolutely need this guidance, this assistance. And Bo, we've got a big topic to tackle, but before we get into that, I want to talk about your practice a little bit
Sure.
and your approach, because when you're dealing with families, parents, and their children, particularly children who have special needs of some sort or another, those parents may not be fully understanding, or it may be new to them what those special needs are, and then trying to bring it into the school system. And depending on where they live, whether it's suburbs, urban, city, county, whatever it may be, it's a wide swath of, oh my gosh, what are we doing?
Right.
So share a little bit about your practice and how you approach these things with families.
Sure. Well, I'll talk about my practice first and then jump right into, um, families and their interactions with the school districts. But we were talking, Bernard, before I came on about when I began practicing law in Alabama, and that was in 2003. And pretty much since then, I have been a trial lawyer, either on the defense side or and predominantly on the plaintiff's side for the last 17 years or so, and have tried uh, nearly 40 jury trials to conclusion in state or federal court in Alabama. And so that's my practice background. And I began doing special education work about 7 years ago, and have slowly over the years done more and more of it. And now my practice has shifted to about 80% of it being special education law. And what that means is, in a nutshell, is I represent primarily children, students who have mental, physical, emotional, or learning disabilities. And um, in Alabama, when a public school system, be it a city school system, a county school system, accepts funding from the United States federal government, and specifically funding from the US Department of Education, that money comes to public school districts with some strings attached. And the main strings attached are that when school districts have students with disabilities, then those students must be treated like all other students who don't have disabilities. And one way the federal government attempts to even the playing field for kids with disabilities is with a law called the IDEA. And the IDEA is the Individuals with Disabilities Education Act, and it puts an affirmative duty on public school districts to provide special education services for kids with disabilities who need it, to level the playing field, to make sure that they get what the United States Supreme Court calls a FAPE, which is a free, appropriate public education. When parents come to see me, most of the time, they are at the ends of their ropes with the school districts. Things have not, typically my clients come to me when things have not been going well with their kids. There's a problem there that no one's quite been able to identify yet, or the grades have suddenly become terrible, or the kids having behavioral problems. And parents don't want to upset the school districts sometimes. And so they come to me, and when they get to me, they're often very, very, very upset at what their child has experienced. So that's the starting point. And it's a tough place for a parent to be, because, we all want what's best for our kids.
Well, certainly, we certainly do. And Bo, I'm sure by the time families get to you, they're exasperated, they're frustrated.
Yeah.
They certainly are not coming to you because they're happy and things are great.
Right.
What percentage of your cases, or I guess, how often do your cases end up in a court of law as opposed to any other avenues by way of reaching resolution to whatever the issue may be? And then as a follow-up, I have a question from a friend of mine, Annika, who lives in Ohio, and this may be a completely different topic, but she says, do you help families with letters of intent? Are you familiar with that term? I don't know if that's an Ohio term, and there may be an equivalent in Alabama. Annika may want to just describe that a little bit. But go back to the first part of that. I'm sorry, Bo.
Sure. So about half the cases end up in what's called due process litigation. And about half the cases are resolved without litigation. And what happens is the parents identify a problem. They cannot work it out with the school district. And under federal law, the parents are allowed to bring what's called a due process claim. And a due process claim essentially says that the school district has deprived the child or the student of a free, appropriate public education. And so that triggers an administrative proceeding at the Department of Education in Alabama that is decided by an impartial hearing officer. And in Alabama, we have 4 impartial hearing officers who hear all of these cases. But even when a parent gets to a due process proceeding, there is a built-in statutorily required resolution period that requires the school district and the parents to sit down, unless they both decide that they want to waive it. But most of the time they don't. They sit down and try to work out their differences. And but sometimes, we're able to work out the differences before, and that really depends on the relationship that the lawyer and the school district start. If I go into that situation threatening and attacking school districts and attacking special education directors and teachers, we're going to end up in litigation. And that's because teachers and special education directors and school administrators have a hard job. And so that's not my approach. My approach is to work with districts as much as I can to reach a resolution that's in the best interest of the student.
I was going to say, Bo, I'm sure you probably get a response often that where a special education coordinator or teacher, whatever their title may be, will say to you or the family, we just don't have the resources from our school district to accompany to be able to meet the needs of child X.
Yep.
And then they'll say, well, I couldn't imagine an educator saying, well, we're not going to even approach dealing with that child because we don't want that child. I know that's not going to be the norm. It's probably, well, we wish we could, but we can't. Mm-hmm. And maybe that forces the issue where you have to go to a higher authority, if you will, to get some guidance that maybe then allows the school district, or puts it on the school district to now be proactive finally. But I know that's not fair because different parts of, and we'll just stay in our state, obviously different parts of our state are better from a socioeconomic standpoint than others, more funding, et cetera. Mm-hmm. While we'd love there to be funding everywhere for all children who have special needs, the reality is it's probably woefully underfunded.
Yeah.
So I guess Let's take a family that just lives out in a very small community and there's just not the resources. How does a family get the proper education for that child?
Well, that is really a responsibility of the public school district the child is enrolled in. And under the IDEA and Section 504 of the Rehabilitation Act, the school districts have an affirmative duty called the child find requirement. And child find means that school districts have to be proactive in identifying kids who may have disabilities that the parents don't know about, or that are not readily apparent, or that may be apparent, but that the child is just has not, the problems, the education problems caused by the disability haven't quite manifested themselves yet. But now the kid is in 6th or 7th grade, school's becoming much more difficult, and all of a sudden it's apparent that child's having some serious learning issues. In really, Bernard, all school districts have to provide special education services, no matter the cost. If a child in the Mountain Brook School District and a child in the Clark County School District needs speech pathology services, or that child has autism and needs a one-to-one paraprofessional during the day, or that you've got 2 kids, both of whom are wheelchair bound and require daily nursing services. Those kids are supposed to get the exact same level of services regardless of the school district that they're in. And that's what the IDEA intends to do. So if you've got a kid who moves from one school district to another, generally speaking, the school district into which the child moves, let's say it's halfway through the school year, has to supply the same services, accommodations, aids, and so on and so forth as the child had in the previous school district. And so the IDEA really attempts to make it so that all kids, regardless of where they're going to school, if they have a disability and need special education services, are going to get the same level of services regardless of where they go.
Well, I know that in a perfect world, that certainly then your job might not be what it is today. And I really do applaud what you're doing, because, Bo, I'm sure there's only a handful in our state of attorneys who practice the type of law that you do. You guys probably all know each other, and I suspect you lean on each other a little bit because you all have similar uphill battles that you face. But one of the resources that you had mentioned is Rights Law, an attorney who kind of sets out all of the resources and things. I'm going to post the link to that website, but if you would share with folks who may be watching us, what is this resource in general? Why would they want to go to this place?
Yeah, absolutely. Attorney Pete Wright and his wife Pam run rightslaw.com, and Pete is a friend of mine, and he essentially is the outside attorney who runs the special education law certification program at William and Mary Law School, which is where I got my certification a few years ago. And Pete has taken several education cases to the United States Supreme Court and has won, and has basically devoted his life to advocating and working as an attorney in the area of special education law. The website is full of frequently asked questions, publications that parents and attorneys want to see, links to laws in every state in the U.S. that parents need to know about. He has important case law for all courts, all federal courts in the U.S. That are written in plain English, easy to understand terms, so that parents can get on there and try to answer, their own questions. It's a very valuable website. And Pete has also written several books on special education law that, are range in length from, 50 pages to 400 pages. And so it's just a resource that's very, that's easily searchable. Parents across the country. I am licensed in Washington State also, and my clients in Washington have the same questions as my clients in Alabama, and that's a good resource.
Well, that's what I was going to ask you. If this is largely a federal issue, federal law that applies, if I'm in Georgia, Tennessee, wherever, and I'm watching this video and I want to reach out to you, are you either able to help that individual in another state, even if you're not licensed there, or do you have resources to be able to help get them to somebody in that particular state?
I would not be able to represent, anyone in an education case outside of Alabama or Washington, but I would also be able to guide parents to an attorney in that state. And one thing I want to mention, Bernard, there is an organization called COPA, and that's an acronym for the Council on, I think it's Council on Parent Attorneys and Advocates, COPAA. And COPA maintains a searchable database for special education attorneys in every state. And so that is also a place where parents can start. Alabama, unfortunately, does not maintain a database on the State Department of Education website that lists attorneys who do this kind of work. Washington does. The state of Washington has an entire roster on the State Department of Education website showing lawyers who do work for free, lawyers who do work for attorney's fees.
Well, that's you led me to my next question is, what if we have a family from a pretty low socioeconomic status? How can they afford the services of an attorney to pursue this type of a matter for their child?
Well, that's a difficult situation to navigate, but the way I handle it is the IDEA has a fee shifting provision in it. So that means that, generally speaking, if a parent and their child are the prevailing parties in due process litigation, then the parent would be entitled to attorney's fees. Practically speaking, when I represent a parent and the parent does not have the means to pay me, I will represent that parent on a contingency fee basis for a short period of time. And if we are able to get the case resolved before the due process claim, generally the school district will agree to pay my attorney's fees for handling that. So that's how we do it. One problem that I had early in this practice was, I said a little while ago, parents come to me, they're really upset usually. That's the state of mind. So they really want to attack the school district. They really want to be aggressive and bring me a stack of documents that are 3 feet high. And then a month later, they've cooled off. They've rethought their position. And this happened to me twice. I did a lot of work to prepare to help the parent. And then the parent said, "Oh, I've decided not to proceed against the district. Never mind. I don't want to do this again." So the way I proceed now, and the way most special education lawyers proceed, is we charge a small retainer to ensure that the parents have thought this process through, and to ensure that they are committed to the process, because it's generally not something that happens quickly, and it's very difficult for an attorney in my niche to really be successful if the parent a month and a half into a special education claim says, you know what, the school district and I have made up, and I don't know who's going to pay you for your 30 hours, but it's not going to be me. So that's something we just have to balance client by client.
No, I certainly can appreciate that. From our practice, we also work on a contingency fee, and it's sometimes it's very difficult. You've put all this time, effort, energy on behalf of the client. They've hired you to do a job, and then emotions shift.
Right.
And it does create a bit of a conflict. That's for sure.
Yeah.
Guys, I'm talking with Birmingham attorney Bo Johnson. We're talking about his practice. It's a very special, it's a niche in the law of helping families with special needs, dealing with education and what should or shouldn't be available to those children. I put in the show notes, Bo, in addition to the Rights Law website, the COPA website. I've also put a link. It's called exceptionallives.org, and it talks about the IDEA Act and explains those things. How can folks reach you? What's a good number, email, website, whatever you got? I want folks to be able to reach out to you to continue this conversation after we're finished.
And thanks for asking that, Bernard. My email address is Bo Johnson, JOHNSON, law, LAW, @gmail.com. And my telephone number is 205-706-4431. And the email is by far the best way to reach me. The other way to get me is on Instagram, and my professional Instagram handle is @Bo Johnson Law, BOJOHNSONLAW.
All right, and I'll put a link to that as well when I find it.
Yeah.
Okay. Bo, we've got just a few more minutes, and let's talk about, once you've done your job, meaning the needs of that child are now being met from an education standpoint.
Yeah.
Is your work as their lawyer necessarily finished? Are you done with the family, or is there a continual need or happen chance for communication with the family going forward?
80% of the work is done. Once the issues with the school district are resolved, we put that in a settlement agreement. And the settlement agreement specifies everything that the child is going to receive as far as services or technological aids. And it generally summarizes something called compensatory education. Compensatory education is education services awarded to put the child in the position he or she would have been in had the school district appropriately served the child up to that point. That document is then incorporated into what's called an IEP, which is an individualized education plan, which would be in existence for every child who has one. So the settlement agreement is incorporated into the IEP by amendment, and then the school district's obligated to implement the settlement agreement going forward. And what I try to do with parents is check in with them at the 30-day point, 60-day point, and 90-day point and say, hey, is the district following the settlement agreement? And if not, help me understand, where we are. And sometimes that leads to additional litigation. Sometimes parents come to me, they've worked out an agreement themselves with the school district without a lawyer's help, but the school district refuses to follow the settlement agreement. And so the parents come to me and say, well, this is what they promised to do, but they're not doing it. Can you help us? And so it's always an ongoing conversation, and but it's not a daily thing, but I like my clients to know that once I help them get to the point of a resolution, they can call me back and say, Bo, things are not, they're not living up to their end of the agreement, or they're not living up to their end of the bargain. Um, but I can tell you, Bernard, 8 times out of 10, the school districts and special education coordinators I deal with work very hard to try to serve these students. And it's not a high paying job. It's not a job that special education coordinators and special education teachers go into to get rich. I mean, they generally care about students, but unfortunately, districts are overwhelmed, and sometimes they they put too much pressure on special education teachers. And so it's important for I think viewers to understand the the balance that has to be maintained in these kinds of relationships. And sometimes you just have situations where teachers and administrators just aren't doing what's necessary, or they're simply deliberately ignoring the needs of a disabled kid. Those are extreme cases. And so, but like I said, my approach is to try to work with the district and while ensuring that I am listening to the parents, trying to understand what the student has been through and see if there's some middle ground. Because I mean, for most of these kids, they're going to be in school for a few more years, anywhere from 8 to 5 or 6 more years. And so it's important for the relationship between the parent and the district to be as good as it can be.
And thank you for that explanation, Bill. I've got one more topic to ask you before we conclude for the day. Talk to us about the scenario where the needs of the child, maybe the medical condition has changed, it has evolved or devolved depending on the child, and then that then creates a situation where what was in place for the child may not be applicable anymore. So the question is, what's the responsibility of the parents once this happens, once there's a change in the medical condition of the child that impacts what is in place for their education needs? What are the parents supposed to do?
The parents ought to alert their child's case manager and their child's IEP team, which is a group of school employees and professionals, which includes by statutory definition, the IEP team includes the parents. And the parents should say, hey, guys and girls, my son's situation has changed. My daughter's situation has changed. We need to make some adjustments. And the parents have a right to call an IEP meeting. And generally speaking, the school district must hold that IEP meeting within 30 days. But generally, that's not a problem. Another situation that comes up sometimes, Bernard, is that there's a perfectly healthy child who does not have an IEP, right? Who's not receiving special education services, but that child suddenly becomes ill, has a severe injury in sports, or has a cancer diagnosis. And so the school district in that situation also has what's called a child find requirement. So if the kid misses a week of school because he or she is sick, the school district needs to be on top of that and say to the parent, hey, can we get together a 504 plan under the Rehabilitation Act to serve your child while he or she is dealing with this disability? Students with autism, it's clearly a disability, but if your kid's a soccer player, breaks his or her leg, and unfortunately contracts a staph infection and is in the hospital for 3 months, that student has a disability that the district has a statutory obligation to serve under 504 of the Rehab Act. And so, but the parents have got to let the district know right? Hey, this has changed with my kid, or you know, this is a new situation. Can we adjust it? And that's what a parent should do.
Well, it all boils down to the communication and not putting
Right.
your head in the sand and just assuming that it'll breeze over, everything will be fine. But that's why families need to seek out Bo and his experience and expertise in this area that is can be highly emotional, very charged at times. But Bo, I want to thank you for sharing a little bit about what you do and the things this part of the world that maybe a lot of people are just not aware of until they're thrust into that position
Yeah.
and don't realize where to even start. So thank you for your time today.
Well, you're welcome, and it was a privilege to be on, and thanks so much for letting me talk about this, Bernard.
Oh, my pleasure. And guys, I put in the show notes the several different, at least 3 or 4 different websites of that Bo referenced. Also, all of Bo's contact information is in there. So please reach out to him, 205-706-4431, bojohnsonlaw@gmail.com. So thank you again, Bo. Appreciate it, bud.
Yep, very welcome. I enjoy being here.
As we do each Tuesday, most Tuesdays, today's Thursday, it is, as I like to say on Nomberg Law Live, interesting conversations with people in their areas of expertise. And you heard Bo's passion for what he does. So I'm so thankful we had this conversation. Thank you guys for the contributions, the comments, and folks watching. We'll be back next Tuesday as we do each week. Hope you guys continue to be safe, and we will catch you next week. Take care.